Appeals. We wanted to tell both of you how much we appreciate you participating in this Zoom oral argument. It is the best way that we can safely conduct oral arguments and allow the court's business to continue. We will follow the same rules of appellate procedure as we do in all oral arguments. Each side will receive 15 minutes to make its oral argument. If you're the appellant and you have reserved rebuttal time previously with Mr. Hibner, you'll be entitled to that rebuttal time. Otherwise, we will follow the rules consistently. Our panel today consists of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case.
Pamela Moses versus Terry Roland et al.
We'll hear from the appellant.
Good morning, Your Honors. My name is John Jones. I am Chief Litigation Attorney for Shelby County, and I represent Terry Roland on this appeal.
Mr. Jones, if you could move a little bit toward the microphone. We're having a little trouble hearing you.
How is that, Your Honor? Is that better?
That's better. Thank you.
Yes, sir. I spoke with Mr. Hibner and asked to reserve 5 minutes.
All right, sir.
For rebuttal.
You may proceed.
If the court please, it's well settled in Tennessee that to prevail in a defamation case, the plaintiff must prove actual damages. As the court in Davis versus the Tennessean said, damages from false or inaccurate statements cannot be presumed. Actual damages must be sustained and proved. That's at 83 Southwest 3rd, 125 at page 128, Your Honors. In this case, the trial court found no evidence of actual damages in this case. The court found that a nominal award of $500 was appropriate. And the rule stated in Davis governs this case. Again, the trial court found no actual evidence of damages. As a matter of law, there can be no recovery for defamation, and the trial court's judgment in favor of Ms. Moses should be reversed and the case should be dispensed.
Are you saying that there is no occasion that the trial court can award nominal damages?
I am not, Your Honor, but in this case, there's no finding that any actual damages were suffered.
Okay. Do nominal damages require actual damages to be found first?
Your Honor, it's the appellant's reading of the law in Tennessee that they do. You cannot have a recovery for defamation, either slander or libel, if there are no actual damages proven. And that was the
what would be the purpose of nominal damages then?
Well, damages may not be able to be quantified in a particular case, and if there has been some form of actual damage proven, nominal damages might be appropriate if economically the damages couldn't be quantified, but that's not this case.
Okay.
Your Honors, I've also addressed in my brief that in the alternative, one of the statements that the trial court found to be defamatory is in fact not capable of defamatory meaning as a matter of law. And with respect to the other statement that Ms. Moses should be watched by Homeland Security, that the evidence preponderates against the finding of the trial court. I'm happy to go into that if the court would like or has questions about that. But I would submit on behalf of Mr. Roland that the rule in Davis applies and that the case ought to be reversed and dispensed.
Let me ask you a question, Mr. Jones. We've got a little procedural glitch here, and I'm concerned if we have a final judgment. The August 9, 2018 order denying in part and granting in part motion for summary judgment, only is signed by Judge Akery. The certificate of service on it is not completed. It's blank. That's the August 9, 2018 order. And then we have an order dismissing Shelby County and Shelby County that was entered nunc pro tunc on April 1, 2019, or entered nunc pro tunc to April 1, 2019 on October 25, 2019. And the actual judgment that was appealed here was entered on May 13, 2019. So if the August 9 order, 2018 order is not valid because it doesn't comply with Rule 58, where does that leave us?
This would be the summary judgment order that Your Honor is asking about?
Yeah, it's the order denying in part and granting in part motion of summary judgment. Yes, sir.
Well, I don't think Your Honor, I did move that be made part of the record.
I'm sorry, I missed that.
I did move that may be part of the record. I didn't address in my motion the fact that there's not a signed certificate of service, but that order is important to the record only to the extent that it reflects that the intentional infliction of emotional distress claim was dismissed on summary judgment. Just that claim is not before the court on appeal. And I don't think there's any dispute about that. I'm not even going into that point. The point is, if those claims have not been disposed of in conformity with the rules of civil procedure, specifically Rule 58, do we have a final judgment? Because those claims would still be outstanding, or perhaps arguably could be still outstanding. I'm not sure how to answer that, Your Honor. I don't believe there's any dispute that they're not outstanding.
Well, I'm suggesting that you may need to do an amendment with a order that conforms to Rule 58. You can take a look at that after oral argument is completed and do as you wish, or will do as we are required by law to do.
I understand, Your Honor. Would there be a certain amount of time which the court would like me to do as I wish? Since there's nothing before us, I can't give you an opinion. I would just suggest that if the record needs to be taken care of, then I suggest you do it as quickly as possible. Yes, Your Honor.
Any questions for the appellant from the panel?
No.
All right. Thank you, Mr. Jones. Ms. Moses, we'll hear from you now.
I'm not really sure what you want to hear from me. I didn't request oral arguments. That they did. I'm just kind of trying to understand what you were just instructing him to do as far as with the judgment. But I'll say
what I'm saying is there may be a question about all the claims being disposed of properly following the Tennessee rules of civil procedure.
Well, I'd say since I got 14 minutes, I'm gonna say what I think needs to be said. And I thank you, Judge Stevens and Judge Golden. Is it Golden? Am I saying it right? Golden?
Right. Yes, ma'am.
I'm a Golden. My family comes from Denmark, Tennessee. My great grandfather's name was Harrison Golden, but I don't think we're related. But I just like to say thank you for giving me an opportunity to speak. I cherish that so much because I've been silenced down here in Shelby County, and Mr. Jones has been my lifetime appointed opposition. Every case that I've ever had, he's been involved. So I just think that y'all need to know that there's some fine people in Shelby County, but there's some people that are not so fine. And Judge Acree, I think he's from Dyersburg too. I'm not sure, but I think that's where he said he was from. But Judge Acree is a fine judge. He's a very fine judge. And Judge Acree doesn't not only base things on the law, in which he does know, but he bases things on what I call just intuition. He heard this case for a long time, and not just this case. He took it after seeing other things that transpired in Shelby County. Judge Acree made a conscientious effort as an officer of the court to pay attention closely to everything involved in this case, including the law. And there is a final order. I'm not sure if it's right or not. I would assume that he's qualified to know how to enter a final order, but things happen, mistakes occur. But there's a final order, and the defendant was only asked to pay, I think, $500 for the defamation. And I'm speaking about the merits, because that's really all that matters to me, is the merits of the case. But I know that as judges and lawyers, you have to look at statutes. But he only ordered them to pay $500, which was an insult to injury. But the judge ruled, I accepted it. I didn't appeal it like I normally do. And they chose to appeal this case. They chose to bring this case to the Court of Appeals for $500 because they did not want to accept any responsibility for the reckless actions that Mr. Roland put in place. Now, here we are, 3-4 years later, and the same organization in which I represent and that I'm affiliated with, he referred to in a negative way, and these type of things are not only dividing our country, but they're unifying our country in a sense too, where race relations are changing and legislation will change as well. And as an elected representative, someone who Mr. Terry Roland was at the time, he had a responsibility not only as an elected representative of the constituents which he serves in Millington, but he had a responsibility to the decorum of government, to be respectful. Well, I guess there's nothing in the law that says you have to be respectful, but it's just usually what you expect out of the people whose salaries you're paying with your tax dollars and your property taxes and the things in which they continue to raise and put nothing back in our communities. And so when he made these statements, he made them, he was asked, just like I'm talking to you today, in a respectful way, to apologize on the record in a county commission meeting. Just like he humiliated me in public, I asked him to retract those statements, because that was what I was taught to do by my grandmother, who's no longer here. If someone offends you, go to them. I went to him before the meeting in a letter, and he dismissed it. He ignored it. It was not important to him. He didn't think that making a statement about someone who was already, public enemy number one would, be harmful. And, words have power. And the words that he said, along with other things that were perpetuated by not so nice people in Memphis, caused me to live under constant fear, constant surveillance, constant harassment, constant just negative light, where a person can't even redeem their character because they're being humiliated by someone who's been entrusted to serve the people. Well, the power is going to always be in the people, because just like the people exist, God exists, and God gave us the law. God gave us the magistrates. God gave us the judges. So you can't talk about the law if you don't go back to the common law, which comes from God's law, which says that you should treat people the way you want to be treated. I've had some things done to me, and I've said some things, but I've never done what Mr. Roland. I never used my power or my influence in a capacity to make someone else feel bad, look bad, or whatever. If I said something about somebody, it was to bring awareness to the things that they are doing or were doing that are hurting people. And that's what we as activists do. We activate and we bring things to people's attention that need to be seen, no matter how ugly, no matter how Black, and no matter how bad they might be. That's how you change the world, by at least acknowledging your wrongs, not continuing to oppress people. And I'm not really sure what I'm supposed to say to 3 men that don't look like me or my father, or my mother. You know, I don't know if there's even a woman judge on this panel. But what I say to you as men, you have children, you have grandchildren, and one day they will sit in your position and you have to decide, will they sit on the same side as Miss Moses? Or will they sit on the same side as you in a position of power to make decisions to impact the country and change things that need to be changed? And that's all I really have to say.
All right, thank you for your comments. Mr. Jones, you've got 5 minutes in rebuttal.
Your Honor, I have nothing to add to what I said earlier. I would waive my rebuttal, and I will heed the court's words and take a hard look at what might need to happen in terms of complying with Rule 58.
All right, thank you, sir.
Thank you.
Thank you, Ms. Moses, Mr. Jones. We appreciate your argument. We'll attempt to get you an opinion at the earliest possible time. Mr. Hibner, we will be in recess until the call of the next case.
This honorable